Okay, so now we're in the 1960s. You've reported that in experimental cell research that human somatic cells have a finite replicative capacity. We have George Guy and others reporting that tumor cells replicate indefinitely. What's your memory? When did it first start to become clear to the scientific community that normal somatic cells age, but tumor cells, maybe because they were karyotypically abnormal, their DNA was abnormal, that they might be fundamentally different? Who was the first other scientists to join with you in pursuing that model?
Well, it's of course impossible to put a specific date on those events. It evolved over a period of many years. I can tell you that in the early years, in the mid and late 60s, the belief that what I had discovered had anything to do with aging was not seriously considered. The focus during those years was mostly on their practical use for vaccine production. But there were beginning to be some people who were able to repeat my work, of course, internationally and find the same event occurring in normal cells. So that part of it became believable after a while. And then the notion that it had something to do with aging became more and more tenable.
Some of the names I think of are, I studied with Sam Goldstein.
Yes.
Sam was an early
George Martin.
proponent. I remember when I called Sam, I was interested in studying aging, and I was calling some labs working in the field, and I discussed with Sam that I was thinking maybe of studying the aging of protozoa. You remember Joan Smith Sonnenborn and that, and Ron Hart.
Mm-hmm, mm-hmm.
And Sam said to me, well, I'm focused on the fibroblast model of aging. That's what he said to me over the phone. And he said, so Mike, I'm not going to, tell you what you ought to do with your career, but if you're going to spend your whole life studying the science, what if you really become to understand the aging of protozoa, but then realize it has nothing to do with humans? Wouldn't you rather gamble that the study of human cell aging, although it may not have anything to do with human aging, at least it's human. At least it's human biology. And he sold me with that argument.
Yeah, very wise man, Sam
He's a wonderful man. There was Sam, there was Vince Cristofalo, who was also at the Wistar Institute.
Yeah, he was a protege of mine at Wistar. He arrived at Wistar and was intrigued by my work and did the first serious biochemistry on the phase 3 or the failure to replicate phenomenon, yes.
Right. So you mentioned then Woody Wright, who joined your lab. I think that was at Stanford.
At Stanford, yes.
Before we talk about yours and Woody's work on trying to figure out where this clock of cell aging exists, what was all this brouhaha about Stanford and as I understand, the NIH and FBI or whatever? What was all that scandal
Well, the
about?
FBI wasn't involved, but what happened?
Federal government certainly was.
A very complicated story. First of all, the start of it was at the Wistar Institute when the interest in using my cells, and in particular WI38, became so great worldwide that I was approached by a fellow from the NIH, Bob Stevenson by name, who said, Len, your cells are being used widely at the NIH and by a lot of our grantees. And he also learned, I had known him through various meetings. He said, I understand that you're overwhelmed with requests for cell for samples of WI38, and that's all that you seem to be doing lately. He said, we would like to offer you a contract to do the following: to store the cells and to distribute them. If you do that, then we will give you enough money to have technicians do all this scut work for you. Well, that was a very welcoming opportunity, and of course I accepted it. And the cells were distributed as I described, gratis to anyone who wanted them, including vaccine manufacturers. The WHO became interested in this because of its worldwide vaccine use implications, and asked me to set up a laboratory for distribution of these cells in London, and also they would maintain my facilities at Stanford and earlier at Wistar, so that this was becoming a huge operation. And in fact, I distributed cell samples and banks to colleagues in Moscow and Leningrad and London, and they were then able to distribute them worldwide, gratis, I might say, at least from my standpoint, they were gratis. It then happened that I moved to Stanford from Wistar, and the contract was continued, but only for people working in the field of aging. The contract was awarded on the basis that it was helping researchers in the field of aging. However, there were dozens, if not certainly hundreds, of other colleagues worldwide and manufacturers worldwide who wanted the cells for purposes other than research on aging. And
for commercial purposes.
Some for commercial purposes, and many, including still many people at NIH, who wanted the cells for research in virology and in many other areas of normal human cell biology. So I was faced with this situation where I had to determine whether the requesters were in the field of aging or not. And that was done very casually. It wasn't all that serious. But there were a large number of people who wanted these cells for non-aging purposes. So I had to set up set up circumstances in which to do this. And I did that. As you well know, scientists have an obligation to provide materials to their colleagues if requested under reasonable circumstances. And I said, I will provide starter cultures for you of WI38 under condition that you reimburse my laboratory for the costs of packaging and transportation for the same amount that the American Type Culture Collection charges, which is a kind of quasi-governmental organization that's in the business of distributing biological materials. So it was for the identical cost. I wasn't going to sit down and figure out what my overhead costs were and this costs were. It was done as simply as possible. And in fact, I developed the first, most people don't know this, the first, I forget what it's called now, there became a name for a document that tells somebody what they can use the biological materials for. There's a name for it. The government developed a name for it and provided a document that people have to sign before they use materials produced on a grant to prevent them from being sued, essentially. But I developed the first one and pasted it onto every bottle that left the lab. And I still have copies of it. Because I didn't want anybody who was using the cells for vaccine manufacture to turn out a vaccine that then caused damage or was killed people or hurt people, and then I would be involved because the cells came from my lab. So I'd appreciate this early on, and anticipated it well before manufacturers of pharmaceuticals did at that time. So over the years, this was done openly. This was not a secret. NIH sent checks to pay for the for the transportation and packaging, and so did dozens of other laboratories worldwide, and especially pharmaceutical companies. And then one day I began to realize, I guess it's after I had a conversation with Maurice Helleman, Merck is making $1 billion gross sales for one vaccine, just the rubella vaccine that's marketed in the Western Hemisphere. And other vaccine manufacturers worldwide, Japan, Russia, Germany, France, England, you name the developed country, and I will tell you that there's a vaccine manufacturer there using WI-38, that these manufacturers are making billions of dollars on these cells, and neither the institute in which the cells were first developed, or the estate of the embryo from which the cells came, or possibly someone who may have funded the research, and there was technically nobody who directly funded the research. It was all bootlegged. And I can tell you that all of the major work that I did in my laboratory was never funded by a grant. I never had a grant. It dawned on me the people who are left out of this equation are the people who gave it value, who gave the cells value, namely Paul Moore and me. Why are the manufacturers profiting and everybody else is left out? Well, that wasn't seriously considered until an event occurred. I believe that this is what precipitated it. I had made my feelings well known about the conflict of interest of the Division of Biological Standards, which was housed at the NIH, who were in the business of certifying vaccines for use in this country, licensing vaccines. And they were in competition with the Wistar Institute with Stanley Plotkin, who produced a rubella vaccine on WI-38, as opposed to a similar rubella vaccine being produced and researched upon by the Division of Biologic Standards at the NIH on monkey kidney cells. We knew that the monkey kidney cell vaccine that they had produced serious side effects, whereas the one produced on WI-38 did not. But because they were in the business of being judge and jury of a vaccine they produced in competition with one produced by the Wistar Institute, it was clear who they would choose when it came time to make a choice. And I felt that this was a serious conflict of interest and made my position known at a congressional hearing in about 1971 or 2, I believe it was. And that resulted in the removal of the director of the Division of Biologic Standards. He was moved sideways, and the whole Division of Biologic Standards was moved from the NIH to the FDA, where it logically belonged. But the people there were very upset with me because of my testimony. And they were upset because they were converted in their minds from researchers at the NIH to regulators at the FDA, which they didn't appreciate. The next major event that occurred was in 1974 or 3, I believe it was, maybe 74. I was offered the directorship of the National Institute on Aging. And I said I wanted to explore what that would involve. First of all, my children, I had 5 children who because I was then at Stanford, could have essentially free tuition at many universities in this country who had an agreement with Stanford and with each other that the faculty children from each university could go to any of those universities gratis. Well, that was a huge sum of money in respect to having 5 children either in or approaching college age. That was one consideration. The second consideration that I posed to them was the funds that were now gathered and continuing to gather at a bank in Palo Alto as to the disposition of those funds. I said, I want to know who those funds belong to and who they should go to, because there are a number of stakeholders involved here. And I asked for that to be done. I said, you have to send to me your most intelligent legal eagle, because this is a very complicated question that has never been dealt with before in law, namely the title to a self-duplicating system. In other words, an ampule of WI-38 is worthless, but that's what I have in storage. What's valuable is the progeny of those cells, many population doublings down the line when their accumulated numbers become valuable. So you need to send me your most intelligent lawyer. Instead, they sent me an accountant who never even, I don't think, could spell the word biology correctly. I said to my secretary and my administrative assistant, everybody in the lab, this gentleman is to be given open access to anything he wants. Here are all the filing cabinets. He should have access to everything, anywhere. Well, he came to the conclusion, he was at the end of his career, and this is speculation. Many people think that what he ultimately did was to embellish his career at the end and make a hero out of himself, because he came to the conclusion, to put it as succinctly as I can, that I had stolen government property and sold it for personal gain, which was a charge that he didn't make in those words, but between the lines you could read that in his report that he made, ultimately, and to which I was not given access before it was disclosed in violation of the Privacy Act of 1974 and published in major journals reporting me essentially as a thief. Well, the upshot of that was that I hired actually a young man in a just emerging law firm in Palo Alto came to me and offered to defend me in a lawsuit that he proposed I make against the federal government, which I ultimately did.
Must have been a few sleepless nights along the way there, you're not telling us about.
Well, it was a very, very serious problem, of course. The accountant went to the dean of the medical school and essentially said to him, do you know you have a thief over there in the Department of Microbiology?
Not tenure track type thing, right?
And after the accountant showed him his NIH credentials, and after the dean realized that 95% of his budget came from the NIH, the dean immediately reacted as you would expect him to react. Well, I better do something about this immediately. He called me into his office, and he and his attorney, at that time it was very rare, but the medical school had an attorney. No sooner did I sit down to explain this complex story when he said, you better get yourself a lawyer before you talk to us. That immediately confronted me with him and with the university. It made a confrontation out of what should have otherwise been a collegial discussion about the very unusual circumstances in which these cells were being distributed to people and for which funds were realized for the cost of transportation and that the funds were never spent.
And it's hard for people in the world of science today to relate, because today it's so well known that what the NIH funds, they make no ownership claim to. The federal government doesn't claim to own any such thing, although they might reserve a march-in right, if they fund.
Oh, yes. Well,
But they don't make any ownership claims. How much of that modern understanding of the interface of the NIH and academia and how the funding works, how much of that you think is a direct result of this conflict you had in those days?
well, it's, I will answer it, but let me preface it with a couple of observations, because you ask a very important question. During the course of this litigation, because we finally litigated it through the offices of a man whose name I want to mention, that's Bill Fenwick, who, because of this case that he prosecuted against the government, resulted in a happy outcome. He became very well known in Silicon Valley and in the biology field in the Bay Area, and has become an extremely successful lawyer in that respect. One of the top-rated and biggest in the Bay Area. So Bill Fenwick came to me and said, Len, first of all, the document prepared by the accountant that was released is in violation of the Privacy Act of 1974, which I happen to know a bit about because I wrote part of that law for Congressman Goldwater, the son of Senator Goldwater, who wrote that legislation. And he said, we believe, because it was violated, we want to prosecute the NIH and FDA and DHEW on your behalf as proof of the value of the Privacy Act of 1974. Furthermore, we're going to hire a group of attorneys in San Jose who are knowledgeable about patents and title to materials. And that activity was begun in the end of 1974. And during the subsequent 5 years of litigation, several very important... 5 years of litigation, during which time I resigned from Stanford in protest to the behavior of the dean of the medical school and the president of the university, who accepted the charges made by this accountant without giving me an opportunity to reply. I should say parenthetically that a substantial number of people from Stanford believed in my cause, encouraged me. And not only that, that ultimately 83 scientists worldwide from Stanford and universities all over the world signed a letter on my behalf, published in Science magazine, protesting the behavior of the NIH in this whole affair. Anyhow, I'd like to get back to what happened during the 6 or 7 years of litigation, because they're key to answering your question. The first thing that happened was that it was not possible during the time that I discovered and made WI-38 and any of those diploid cell strains to patent living things. The patent office was not capable legally for doing that. They were during this period of litigation as a result of what's called the Chakrabarty decision. A decision made, I believe, from Monsanto, I believe it's Monsanto, who developed a microorganism that digested petroleum and produced out of it something that was tantamount to perfume, so that it was a very valuable observation, and they wanted to patent this bacteria. And they had deep enough pockets to take it all the way to the Supreme Court, and the Supreme Court then ruled that you can patent living things. And that has exploded, of course, into the development of the whole biotechnology industry as we know today. The second thing that happened was that at that time, there was a development of the nascent biotechnology industry, the emergence of Genentech, Amgen, Cetus, and several others who realized that their companies were founded on taking materials, essentially recombinant DNA materials, from their laboratories and opening up those three companies. And those materials were being produced, of course, under NIH grants, taxpayers' money. And that was one of the arguments that the government had proposed in their defense against my case against them, and that is that I had been using taxpayers' money for these purposes. Well, of course, I didn't use any money. It's never spent. In any case, these companies, these nascent companies, told Bill Fenwick, my attorney, that they would be happy to produce amicus briefs at the time we went to trial, because if I failed to win this case, they would all be out of business, which was in fact correct. In fact, they had done far more than what I was accused of. They were building companies on taxpayers' money-funded products that they took from their own laboratories.
Absolutely.
The third thing that happened was President Reagan decided in an executive order to enforce a rule that said anything produced under a government grant or contract that had commercial possibilities would be allowed to do so with government rights, whatever rights they might be, but it would be permitted. And that was key, as well as what ultimately happened, and that was the Bayh-Dole Act, which incorporated into law precisely what President Reagan had provided in a presidential executive order. Well, the government, after these 3 or 4 events, also found itself working both sides of the street, because by this time they had developed at NIH a procedure in which annually there would be a conference held in which the products from NIH laboratories would be shown in the science fair to commercial entrepreneurs for exploitation. And on the other hand, they had filed their own suit against me, as the usual legal proceeding. When one files a suit, the other party files a suit as well. And so they found themselves in an impossible situation, playing both sides of the street. And so they came to my attorneys and asked for an out-of-court settlement. I had a contingency arrangement with my attorneys in which they were obligated to go to court, which is a very costly procedure, if I insisted, and would not accept an out-of-court settlement. Furthermore, my family was suffering when I resigned from Stanford in protest to the behavior of two or three of their officials. I ended up in a what do you call it, unemployment line, where I was paid $104 a week with 5 children, which was not very satisfying. In addition to the pain of the litigation, my wife and kids were not happy under these circumstances. As a result of those considerations, I decided to negotiate with the feds in respect to the out-of-court settlement. And we did reach an out-of-court settlement in which the funds, at the outset of the lawsuit, I might mention, it's important to mention this, we decided to take the funds that were in the bank that I had received for payments for the packaging and distribution and mailing of the cells, which at the beginning of the litigation amounted to about $15,000, I think. So we're not talking about an enormous sum of money here, but we decided to put that money in an escrow account, and the escrow read that whoever won the court fight or the out-of-court settlement would win the funds. And we invited the government to participate in this endeavor in order for us to wear the whitest possible hat that you could wear. And for reasons that are inexplicable, the government refused. But we did this unilaterally. We said to the bank, here is the $15,000. We want this money distributed to the winner of the case, and the bank should decide who that should be. So that's the way it was left. During those 6 or 7 years, you may recall, interest rates were enormously high. They're up 12, 13, 14% a year. Many young people don't appreciate that. So the money skyrocketed to about $80,000. The out-of-courts, so we reached an out-of-court settlement, and the government said, we don't want the money, which precipitated the case in the first place. They said I was a thief and stole, and here they're saying at the end, we don't want the money, you can have it. Well, the money all went to my attorneys, whose time was far in excess of $80,000 worth. So they were lost, actually, although they gained in the sense that Bill Fenwick and his organization became very well known on the peninsula in areas of title to biological materials, although that has, to this day, not been settled. It is not settled law who owns a self-duplicating system and what parts of the system they might own. So the seriousness of that question remains to be settled, if it ever will be. So the case now was settled. I should also mention that prior to the litigation, and what also forced my litigation against the government, was the fact that the government, in my absence, sent people to my laboratory to remove all of my ampules of WI-38 in my absence, which was, as I characterized it to a couple of reporters with whom I spoke at the time, typical of Gestapo-like behavior. They waited till I was gone before they went into my lab and removed ampules of WI-38 and took them to Washington. Part of the settlement was the return of many of those ampules. And in order for allow the government to save face after what was a negotiation, you had to give something to them. They kept some of the ampules, but they screwed them up in the long run, and they essentially became worthless. My ampules were fine, and I ultimately gave them gratis to the Coriell Institute in Camden, New Jersey, which is a major repository for biological materials. So, getting back to the science, if you'd like to...
Well, it's the research is driven by money, and sometimes money's made with research, and there's a lot of lessons to be learned here. But yeah, so as a biological scientist, I mean, the interface of government and NIH funding and all that's quite interesting, but the biggest legacy really here is groundbreaking discovery that human cells age, back to basic science. So I had the privilege of working some years in Dallas with Woody Wright, who's one of your students years ago. I also studied with Jim Smith and Olivia Smith, Pierre Smith. I remember once Jim talking about Woody, I think somewhat in a negative light, saying, Mike, Woody used to sleep on the floor in Len's lab, as though that was a little off, a little kooky. But the Woody I know...
Well, Thomas Edison slept in his laboratory too.
That's right. But first off, is that true?
Well, I have to tell you that this is the first time I've heard that, but it doesn't surprise me. Woody was a dedicated scientist. I thought you were going to tell me something that some people thought were negative. In fact, they came to me with this negative question, and that is that Woody was a very sloppy experimentalist, and he didn't clean things up, and he left things messed up and unwashed, and that was very annoying to some people. And they came to me and they said that, and I said, well, it's a trade-off. Woody, as we all know, is a very good scientist. He's a very hard worker. And if I have to pay the penalty of him having a dirty lab, and even if I have to clean it up myself, I'll do it.
I'll reinforce that with my own story. This is about you and an interview with you, not with me, but I was, as you may know, after my Ph.D., I'm a medical student in Dallas and was doing research on the side. One day I was looking for a camera, and I was working just around the corner of Woody and Jerry. They actually gave me a lab to work in as a medical student. It was just very, very gracious fellows, Jerry Shea and Woody Wright. But I was looking for a camera, and I walked into the lab, and as you may understand about Woody Wright, very dedicated, very rigorous, one of the finest scientists I've ever met. Bent over as a senior, I think he was full professor at that point, always in the lab, bent over electrophoresis apparatus, loading a gel. And I'm asking around the lab where this camera is, and one of the technicians reached over Woody's head looking for this camera and pulled on top of Woody a carboy, a big plastic jug full of ethidium bromide waste reagent, which is highly carcinogenic, right on top of Woody's back. So what does Woody do? The man who sleeps on the floor in the laboratory continued to load the gel, knowing that he's just been drenched in a highly carcinogenic chemical. After he had loaded the gel and started it to run, then he says, I probably should go take a shower. Went and took a shower and then held a UV lamp up to his back. It was glowing like something out of a science fiction movie. To this day, I worry that that might have caused him long-term health problems.
Oh, really?
But that was the sign of a dedication and of a great scientist to his work.
Yeah.
That gel, the answers, the scientific answers that gel would give him was more important than his own personal health.
Yeah.
That's the kind of man Woody
Well,
was.
I hadn't heard that story before, but it's typical.